Good evening, chat. Hello. Friday night. It's Good Friday. Hopefully, well, today, Jesus died for you, your sins. Remember, he wasn't just some guy, wasn't just some bro. He was the Son of God. So keep that in mind. Keep that in mind. But anyways, chat, I guess happy Good Friday. Let's get started. It is Friday night. I am Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area, and tonight we are talking about the motion to dismiss that was filed by Kiwi Farms against Russell Greer for his garbage lawsuit out in Utah. Yes, where the farms is the hardship, according to Mr. Greer. So we are good to get started on that. If you guys are new, I've done a couple of updates on this lawsuit and did a couple I've done a couple of updates on this. So if you guys want to, you can follow along there. There are previously ones out there. Geez, I'm still coughing crap up. But anyways, we are going to get started on this because this is some entertainment that's out there. There's no Baldo news. And if you guys want to talk about it, yes, Nick got sentenced today. The court placed him on probation for 5 years, which I was like, ooh, wow. He's on probation for 5 years. Basically, it's like he's on a 5-year plan. So very Stalin-esque for a 5-year plan. I'm sure he doesn't get that reference. Anyway, he's got a jail report date of August 1st, and it appears that jail report date is going to be suspended so long as Nick actually complies with the terms of probation and acts like a housebroken good boy. If he keeps doing what he does and worrying about the fun police and thinking that drugs are cool and do whatever he wants, yeah, he might do 30 days in jail. But for right now, he's got a chance. He's got a chance to show himself that he can act like a civilized human being. So we shall see. We shall see how this goes. Hopefully he can do it. I mean, he did go in there and tell the judge how smart he was, and everybody told him he's so smart. Well, he could show us how smart he is by following written directions. The Scandinavian prudes came down hard on him today. Well, yeah. It's a car loan term for probation, yes. Yes, KRM. As he said, he would never lick the boots of government, and he walked down there and was just, scrubbing them clean. But honestly, it's not. You're not doing it that way. So, just saying, like it's not like he's trying to fix his stuff, and he gets to take advantage of a dismissal. Why wouldn't you take advantage of that? We'll see if he can do it. Brian says, "What's got to happen now between August 1st for him not to serve 30 days?" I don't know specifically. I'm assuming a lot of it is he hasn't been on drug reporting and alcohol reporting this entire time. Remember, Nick paid money to not want to have to go test. So now they have to figure out, can you even maintain sobriety? He's got to go get a drug and alcohol assessment. He's going to have to start going to group meetings, whether it's group, intensive outpatient. They're having him go to what's cognitive therapy. Now, guys, that doesn't mean he's like retarded cognitive therapy. It's a program, if you Google it, it's called Thinking for a Change. They call it different things out there. But basically, it's the idea of you have antisocial and criminogenic thoughts, behaviors, and actions you undertake, and we need to get you to stop doing that. Like, you have to stop and say, I'm doing things that are bad. Maybe I shouldn't do these anymore. And then you go, okay, well, what do I do to fix these? I need to have positive thoughts. Good thoughts. What do I do? How do I make those thoughts? And then the final part of Thinking for a Change and these types of things is you start learning about how do I develop coping skills. And I don't mean in a joking way or a bad way. Coping skills. How do I handle myself when things are getting tough, when things are getting bad, when I'm getting stressful? What do I do to avoid being in these situations where I use and make poor choices? So when it comes down to that, it's always like people, places, and things. You don't do stupid things in stupid places with stupid people. If you avoid those three things, everything's great. If you avoid like one of the three, you should be okay. If you avoid two of the three, you're doing really good. So there are options for him, but we'll see. We'll see what he can do. We'll see what he can do. But that's what some of the basic stuff. Like for right now, they have to assume he can't function like a member of society right now. So they're going to have to we need to check to make sure we don't need to housebreak you. And if they do, they will housebreak him either by boot heel or by the kind word, but it's going to be up to him by which method. So, will I be stream sniping Nick tonight? No, I don't. No point. So, other people will look at it and record it, and we can, you can laugh later. So I'm sure it's not going to be a banger. What's his length of probation? 5 years. 5 years. So, will his community service schedule be publicized? No, because they don't part of it is you do it, but they don't want to start embarrassing people because that's not part of the incentive. Like you go out there, clean the trash, or you do things in your area. Now, every once in a while, courts can use humiliation as a tactic. I remember when I was in law school, one of the county fairs near us, a guy had to clean stalls at the horse barns. And he had to clean stalls at the horse barns, and he had to wear a shirt that says, "I abuse horses." And the guy had a couple of horses on his property that almost starved to death. So there are times when that does happen, but this is not going to be one of those times. And generally, for a lot of your community service, you could do community service at any not-for-profit organization. And depending on where you're at, that may allow you to work at churches too. So there's a lot of places like Nick could go do it proactively. They're not just going to make him come report and them have do things. Shredder says, can probation be reduced? Certainly, the court always has the discretion to modify sentences at any point in time. If we get 2 years in and Nick is spick and span and perfect, the court could say, yeah, we'll terminate early. But, this court is deciding we need to make sure we're in for the long haul. So, we'll see. Does that include going to charity art events? Yeah. Will he stream? I don't know, guys, because as Alyssa says, it's almost 11 and still no stream tonight. All right, so before we get started, I guess I'll get through all these real quick, and then we'll get to Russell Greer. Blade 2.0 gifted one sub. Thank you, Blade 2.0. Remember, chat, what's better than a knife blade? Blade 2.0. It's even sharper. 4M70. 4M470. Sean and chat, happy Easter. Well, it's good to see you. Hope you're doing well. It's been a little while. Glad to see you. Glad to see you again. Sleazy's been a member for 10 months. Thank you for the support. Says, Sean got felted today. Eat your crow tendies. I don't think I did. I said he wasn't going to jail, and actually, he's not going to jail today. So I think I won. I think I won there, chat. But if chat determines I didn't win, I'll pay up that 20 pounds. Devil-Eyed Elvis, good to see you, man, for $10. Says, gonna need the lovely Alyssa clips to clip how late Sean is every stream. Thanks. Oh, Nico says, for $5.09. I'm doubting Nick will stream sober tonight. 9 cents for 9 of the 99-cent pours. 509 BC marked the founding of the Roman Republic. Hashtag sandwich squad assemble. Thank you, Nico. Oh, Bifron's has been a member for 16 months. Says, like the stream. Yes. And then Unforced Ego for $50. 50 big dollars. Thank you. Thank you for the support, you guys. It says one Kayla Nude unit, the KNU. That's a new currency. That's a new commodity that we have now. Is it, in support of Hardin's quest to quell this retard. Yes. And it's funny, are we pegging it to the... Got to be careful using that term when we're talking about this situation. But are we pegging it to the dollar? Is it going to be to the yuan? What are we doing it to? Oh, I think we have to. I think we're pegging it to court orders at this point. Hold on, what? I don't know. Why, do I look like I have liver cancer right now? I don't know. Do I look like I know what the hell's going on? Seriously, do I look like I know what's going on? Hold on here. I'll fix it. I'll put on auto. I don't know why, like, people aren't. Yeah, you jaundice as fuck. All right, well, let me fix this here. There we go. That should be better, right? I think it's better. Yeah, I don't know, because, like, I have it set. View, we'll save this one, and we'll come back to it. It's like, because if it's moving again. God damn it. Why, like, I click on settings, and it does this shit. It's so fucking annoying. Exposure rate, autofocus, white balance. Maybe that's what I need to do. Is that part of my issue? The white balance is getting messed with? Let me see here. Yeah, see, that's really white or really yellow. There we go. I'll just leave that on manual and see what happens. There. What? No. No, it's not on. So I don't know what the hell's going on. So, all right. So whatever. We're gonna fix. We're gonna keep moving here, chat. Swarthy Sean, yes. But we're gonna have to tie the it's gonna be the first commodity and currency ever pegged to a court order. That's gonna be funny. But like I said, we have to be careful pegging in this situation. Sika Loader for 10 Singapore dollars. Thank you very much. Saying, what are the odds that Ricada, unable to deal with the day clean, let alone 5 years, would violate the probation, head to jail for a month, return to drinking, doping, and endangering connections? I mean, if he does that, he fucking loses the ability to get a deferred adjudication. He probably the court could give him even more jail time. So it's not just like the 30 days is a one and done. They could give him a lot more time, I presume. But if he doesn't, then the court says, fine, we're terminating you unsuccessfully. Go fuck yourself. So Nick's got an incentive to comply. Unforced Ego for $5 says, can we hit it? It's a copyright dispute if you want to know the truth about it. Yes. Fred Rush for $10 says, who's going to set up the betting pool on Polymarket for failing probation? All right. And then Schnauzer Patrol for $4.99 says, make Nick clean bathrooms at Stoney's. Oh, no, chat. That's not. No. All right, guys. So we are going to get started here. It is time. It's time. Supano says, make him the designated driver at Stoney's. All right. So here we go, chat. We've got this motion to dismiss. Now, here's how things work in this case. If you guys remember, this case had been dragging on for 4 years, got transferred down to Florida, and it came back. Russell Greer, in the meantime, had also appealed it up to the 10th Circuit when he lost at the initial motion to dismiss. And the court said, well, actually, he's pleaded enough to survive motion to dismiss. So it came back. We're now at the point where Russell's case has fallen apart. There's issues with discovery. There's issues with the witnesses. So he asked the court for a chance to amend his complaint. Well, when you file an amended complaint, everything from the previous complaint is gone. So, for example, if you include a claim in your amended complaint and then you don't include it in the new complaint, it's gone. Everything up to that point, well, it's gone because you're alleging new things, which that means you get to then, if you're responding, you get to assert new defenses because you didn't get the chance to defend this properly before the first time. So that's where we are. So that is what's happened here. After Russell filed his amended complaint, Matthew Greer's like, oh, well, you know what I can do? I could file a motion to dismiss because it's a new complaint and it's timely. So he goes ahead and files this. And I think this was very well done. This is something he's been working on for a while. He's been planning. He's been planning and plotting. So this is Joshua Moon and Lolcow LLC's motion to dismiss. It's Russell Greer versus Joshua Connor Moon et al. Now, remember, what are they dismissing under? Federal Rule 12, 12B2, 12B3, 12B4, 12B5, 12B6, and 12B7. Now, guys, we know what 12B6 is. It's you fail to state a claim upon which relief can be granted. But what are the other ones? I know we've gone over them before, but I think we need to touch on those again because it's important. It's part of the rules of civil procedure. Now, how do you do this? So you go to the rules of civil procedure, and it says defenses and objections, when and how you present them, motion for judgment on the pleadings, and then how you consolidate motions, waiving defenses, and a pretrial hearing. So here's how it works. They say, unless time is specified by this rule, the time for serving a responsive pleading as follows. You must serve an answer within 21 days of being served with a summons and or a complaint, or if you have timely waived service under Rule 4, within 60 days, or within 90 days after it's sent to a defendant outside the United States. Okay. Now, these are the other parts of this, but we need to move on to what you actually can do here. So you talk about how to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion. You have to assert these defenses first. If you file an answer and then these, it doesn't count. You have to file these first. So 1, the lack of subject matter jurisdiction. Okay. Now, in this case, we don't have that. So that one's not important to us. But the lack of personal jurisdiction, that's critical. Are there enough minimal contacts to draw Lolcow LLC and Josh into the state of Utah? Is it an improper venue? Yes, we're arguing it is an improper venue. And we go through the rest of them. Insufficient process. There's issues about serving people. Insufficient service of process. Failure to state a claim upon which relief can be granted. The old reliable. And then finally, a failure to join a party under Rule 19. And we're going to get to that because what's Rule 19? Rule 19 is joinder. And you have to do it to the required joinder of parties. So, for example, in Russell's case, one of the big parties here is all this crap with this copyright material is being hosted on a Google Drive account. So Russell needs to bring Google into this, but he won't because Google will crush him, and he knows that. So that's why Russell's running away from that. But as a defendant, you have the right to say, Your Honor, these people are critical to the case. They have to be brought in. And Rule 19 allows you to do that because you can have required parties. And, they're subject to service, and they're also, involved in the subject matter jurisdiction. In their absence, the court can't completely accord relief. That person claims an interest relating to the subject matter. It is so situated, if you dispose of the case, it may impede their ability to protect their interests. So, for example, if the court makes a ruling on who owns something, and there's a guy out there who actually owns an interest, he could lose his interest. It would affect his interest. It would cause a problem because the court said, well, Bob now owns everything, but Steve is out there saying, wait. I've got a half interest in this. You just took that away from me. Now he has to fight. You have to worry about inconsistent obligations. You have it's got to be consistent rulings out there. And that's why you need everybody on a case that's involved in a matter. That's what we're looking at here. So that's Rule 19. So let's get back to what Hardin Farms are going after. So they're incorporating it by rule of law in the introduction. So you see here, the plaintiff, ostensibly a Nevadan, improperly began his litigation 4 years ago in a court that had no personal jurisdiction over Josh Moon, a Floridian, or Lolcow LLC, a West Virginia LLC. And then, unsurprisingly, Greer never effectuated service upon the Floridian he sued, or upon a West Virginia LLC via any means other than email. And there are means of you can ask for alternative means of service, but you have to show I've tried all the other proper means first. So his first attempts to get alternative service were denied. So, and it's because Russell made no showing he had even attempted proper service, because Russell can't afford to have a process server. He can't afford to serve him, so he wanted to use email. And yes, the former defense counsel in this case, Scortis, declined to raise the jurisdictional bars in his motion to dismiss. Greer has voluntarily chosen to amend his complaint and render those former pleadings of no legal effect. That's true. We are in a new complaint, which means we have new defenses. And Russell has included new parties now. Rustard and Mosif Jartelli, those are people from the farms that Russell wants to go after. So now we have new parties, involved that we have to go after, here. So, okay, real quick, over on Rumble, we are live tonight on Rumble chat and Twitter, as well as YouTube. Logistical Nightmare for $20 says, blessed Good Friday. Well, thank you. I hope yours was very good as well. I hope Hardin finally quashes Russ's extended floundering. I think we're getting to that point, chat. Now, we're addressing this matter here, and it says, thank you again, Logistical Nightmare. I appreciate it very, very much. It says, the defendants now have the opportunity to relitigate this case from the beginning and raise the fatal jurisdictional and service problems that preclude this court from entering any judgment other than one of dismissal. Now, this is a massive footnote, so let's figure out what this actually says here. Now, for the purpose of preserving their objections, and this is important, you preserve your objections. Always make that clear. Even if you know they're being preserved, and you can write it. You can write it 1,000,000 times, and it doesn't hurt you. It's belt and suspenders, chat. That way you'll never get caught with your pants down. So they point out that the 10th Circuit opinion in Greer versus Moon was erroneous. And they're allowed to say that. They're allowed to say, Judge, 10th Circuit case, bullshit. Don't listen to it. Alternatively, additionally, to submit the amended complaint is substantially similar to the original complaint. And the court should dismiss the amended complaint for the same reasons to dismiss the original complaint. They also submit that although the motion for joinder and motion for a more definitive statement and motion to strike were all filed in response to the original complaint, those same arguments are all equally applicable to the amended complaint. As such, they incorporate those filings by reference here rather than filing renewed separate motions. Now, this is a way to do it. The court will probably allow this just for the sake of not cluttering up the docket, but they might say, no, refile your motions. But that's why you do this. You make sure the court knows everything you want to do. Everything you want to do. Now, they go on to the part of the motion to dismiss. You assume the truth of the plaintiff's factual allegations. And that's true. Remember how that works. When you're doing a 12b6 motion, you say, Your Honor, let's presume everything Russell's saying is true. He still states to fail a claim upon which relief can be granted. And the court has to look at it and say, yeah, there's still nothing here, Russell. Sorry. Well, they point out that when you're proceeding in forma pauperis, meaning Russell is proceeding as a pauper, he's indigent, there's an exception to the rule. The court should dismiss a complaint when the plaintiff can't corroborate any of the facts he alleges. He has to basically do that. Now, they point out Mr. Greer admits he cannot corroborate any of his factual allegations because he has disclosed 2 witnesses and later withdrew those witnesses. He also stipulated he would present no testimony in his case in chief. Now, I remember we went back to this where Russell said he promised he won't testify. I think the court's still going to allow Russell to testify if it ever came to it, just for the sake of avoiding any potential issues at appeal. But there's still all kinds of problems here, and I think, like I said, we're getting to the beginning of the end. I mean, we're definitely at the end of the beginning, but I think this is now the next step. And if you guys were wondering, in the case that Russell has with the farms, the last filings we covered, this is the next filing. There hasn't been anything there for 2 weeks. So very quiet. It was a very strangely quiet situation. So this is the next filing. Now, they point out the lack of jurisdiction is not the only thing that should precede this case from going further. Greer's also failed to state a claim, and he failed to join or even make the most basic attempts to serve the necessary parties that Greer has added to this litigation. And those are the two of Mosif Jartelli and Rustard. You know, Russell Greer has not made any efforts to obtain their identity. So what the hell are we going to do? More importantly, Russell's never disclosed that these guys have information that's discoverable in this case. So they can't proceed. Russell has parties named that we don't know shit about. And it's not like when you sign up for the farms, your name's available. So there's nothing that can be done. So they point out that Greer is proceeding as a pauper, once again, as a brokey. It's such his contentions need not be accepted at face value, and the court can pierce the veil of the complaint's factual allegations. And they say Greer confessed he intends to present no testimony at all, but the plaintiff bears the burden of proof in contributory copyright cases. Yes, he bears the burden of proof, period, because he's the plaintiff. And because he stipulated he intends to present no testimony, Greer can't possibly carry his burden of proof. The court should therefore dismiss the case outright, or controvert the incident's motion, the motion for summary judgment, in light of the manifest inability to proceed to trial. Now, we're not just dealing with the 12B6. Remember, we have the other 12B motions here. So the plaintiff has the burden of establishing the court's jurisdiction over defendants. And the court can allow the plaintiff to carry that burden by various means, to include declarations, affidavits, or an evidentiary hearing. Any judgment entered without the plaintiff first establishing jurisdiction is void. It's therefore imperative this court establish whether there's jurisdiction at the outset before further resources are wasted. And to survive a 12B6 motion, and this is where you get to, you must contain sufficient factual matters accepted as true. And this is where the problem, we've already talked about this. We're going to skip that because it's already there. But we move on to the jurisdictional, venue, and merit arguments are addressed below. There's no personal jurisdiction over Josh Moon or Lalcow LLC. There are no facts that allege there's jurisdiction. And the jurisdiction is lacking for two fundamental and unrelated reasons. The first one is Josh Moon and the LLC, of which he is a sole member, because he's the sole proprietor, are not Utah residents and have never done business or established any relevant nexus to the state of Utah. Now, chat, remember with that nexus thing, that's where you get to the minimal contacts. I've mentioned the Supreme Court case before, international shoe. That's where you could sue and use the state's long arm statute to draw people in. There are no business relations. Josh has never availed himself to the laws and protections of Utah, nor is Lalcow LLC. Now, some of you might say, well, wait, he does the internet, and the internet reaches Utah. That is not a sufficient way of establishing jurisdiction alone. Just because the airwaves touch that area does not mean that, because otherwise there'd be jurisdiction in every federal court in the country, and that would be preposterous as well. And it says, second, the court cannot exercise jurisdiction over defendants without establishing such jurisdiction by way of a proper summons served within valid territorial limits. So therefore, it must be dismissed under lack of personal jurisdiction, lack of process, and lack of improper service of process. And that means actually having him served properly through a process server, or, like a sheriff's deputy serving. The plaintiff alleges that they have personal jurisdiction because they've intentionally availed themselves of the jurisdiction. But Russell's complaint is circular at best and incomprehensible at worst. Greer alleges the defendants have intentionally availed themselves of Utah's jurisdiction only because they allegedly committed various actions of copyright infringement. Russell Greer does not allege the infringement ever happened in Utah, or even that the infringement has any connection to Utah. I mean, typically when you sue somebody for copyright infringement, you generally, if they live in America, you sue them in the district where they live because that's where they committed the copyright infringement. There's a presumption that way. So Russell should have gone to the Northern District of Florida. I'm saying that now because even if Russell hears this and tries to do it, it's too late. Nobody's going to let you move around. Even Hardin's going to say, fuck it, we're here now. Now, Russell admits that Josh Moon resides in Florida. He's a Florida resident. Josh Moon is a Florida man. Greer makes no allegations about the residents of Lolcow LLC, stating that only Lolcow LLC owns a website. But the public records reveal that Lolcow is a West Virginia LLC, and the defendants freely proffer here that Josh Moon is the sole member of Lolcow LLC. Additionally, because Greer has stipulated he will not call any witnesses, it will be impossible for Greer to prove jurisdiction. And that's the point, because when you have witnesses and evidence you present at a trial, you have to present venue and jurisdiction. It's critical in criminal cases. That's why, guys, when we watch criminal cases, you'll see generally when you're speaking to the cop, you'll say, hey, Officer Bob, did you stop this guy? Yeah, where did you stop him at? I stopped him on East 181st Street and Fairfax Road. Oh, okay, officer. Is that in the city of Cleveland? Yes. Is that within Cuyahoga County? Yes. Is that within the state of Ohio? Yes. Bam, you've established venue. You've established this is the right court to hear things in because you're in Cuyahoga County. You're in Cleveland. Then you've also established jurisdiction, the proper jurisdiction. Now, let's say they don't say what county it was in. Well, I don't know what county it's in. And some of you might say, well, can, the prosecutor say, Your Honor, can you take judicial notice? The city of Cleveland's in Cuyahoga County, Ohio. You're not allowed to take judicial notice of elements of an offense. The state has to prove them. And I've gotten cases dismissed that way. And it's hard to do because you generally sit there and you have your checklist and they've missed something. And you have to act like they haven't done anything wrong. And sometimes they even catch it themselves and they have their last witness. And you can have a lay witness, like an eyewitness something, say, hey, it happened on East 181st Street. Yeah. Is that in Cleveland? Yeah. Is that in Cuyahoga County? Yeah. Is that in Ohio? Yep. Proven. So there are ways around it. So he can use other witnesses. He can use witnesses to show it. He can do a lot of things to show this happened, but he's not presenting any of it. Now, the only other way you could get it in is if the party stipulated. So Josh and Lolcow LLC could stipulate to jurisdiction. They could stipulate to venue. There's no way that ever happening. But they could. That's the only other way around it. That's the only other way you would get around it. So you can also do it sometimes at a pretrial evidentiary hearing. Sometimes that works, but generally you're going to have to do it at trial. Like when it's time to fuck, it's time to fuck, chat. So the plaintiffs bear the burden of establishing personal jurisdiction. And the 10th Circuit, stroke brain, has held the specific case of LLCs. The relevant and purposeful availment test requires an analysis of whether the LLC availed themselves of the privilege of conducting business in the forum. So as I said, chat, are you availing yourself to the rights and the laws and protections of the state of Utah? And LLCs are treated as sharing a domicile with their members. Personal jurisdiction over an LLC requires personal jurisdiction over those members. Well, there's only one member, Josh. So they say, and even if the plaintiff could demonstrate purposeful availment, that is not enough standing alone. You can still escape jurisdiction by establishing it would be incompatible with traditional notions of fair play and justice. Because you're like, look, yeah, I availed myself once 20 years ago, or it just doesn't work that way. And there's problems. Josh Moon was in Florida. And, the LLC's in West Virginia. He alleges they've availed themselves, but he doesn't explain how they did so other than by allegedly infringing copyrights, which is a conclusion and not an allegation. There's no allegation that the LLC does business in Utah, or that even Josh Moon has ever set foot in Utah or conducted any sort of activity in Utah. Now, here's the thing, guys. If you go on a vacation there, is that enough to establish minimal contacts? No. It's the idea you've conducted business. You did the action there. You're doing things. Like, oh, I flew over in an airplane and we had to make an emergency landing in Salt Lake City one time. That doesn't establish that. So don't get worried about that. Like, oh my God, I've driven across America. I could be served in any state. No, that's not how that works. Hold on. Hold on, shit here. Okay. So, and these are the problem is here. It's difficult to imagine how they availed themselves to the jurisdiction of Utah, and even more difficult to imagine how to exercise jurisdiction here in a way that makes sense and that's fair. There's nothing here you can do that for, and that's a problem. This is not fair. Now, normally, I know you guys might sit there and say, well, you can't just say, oh, it's not fair and cry about it, but this is a time where courts are critical about making sure things are fairly done. Because otherwise, it's not fair to anybody. This is not how we set up our court system. No, it was not a shower text. Actually, somebody I give a shit about. So, somebody I was looking forward to hearing. Let me see here. Actually, hold on. Did I just get a voicemail that popped up on my phone? Let me see here. I hate this. You refresh it, nothing happens, and later you refresh it later, and it's like boop, like 3 or 4 pop up. Okay, nothing new. All right, good. So. All right. Sorry about that. We're back. We're back now, chat. And it says, perhaps Greer knows that Mr. Moon. I love Mr. Greer knows that Mr. Moon. I love it's like Mr. Moon is a Floridian and Lolcow LLC is not conducting business in Utah. And because of that, he granted this court to leave for alternative service. In that motion, Greer admitted Mr. Moon's last known address was in Pensacola, Florida. Greer stated in that motion he had made efforts to locate Mr. Moon, but Greer did not explain what those efforts were. The court granted the second motion for alternative service, but that was erroneous as a matter of law and entirely ineffective in allowing court to exercise jurisdiction on an out-of-state defendant in the absence of even minimum contacts with Utah. I know, guys. See, it's like on those phrases you're hitting on. The federal rules of procedure, civil procedure, do not permit service of process via email. And the only way email service can be permitted in a case involving service of process against a defendant that is not located abroad, and that's when you can do it when they're outside the United States, is by reference to state laws incorporated under Federal Civil Rule 4E1. And some states allow you to do that. But Utah has strict state law procedures that must be met for service of process via email can be authorized. Notably, Utah requires a motion for alternative service must be accompanied by an affidavit or declaration, and you have to explain why traditional service can't be accomplished. In Florida, where Josh was served, flatly prohibits service of process via email. So now you run into a problem. You can't serve some, if state law bars that, you can't serve them. Now, none of the requirements of Utah law were satisfied Russell, who stated in an unsworn pleading that he had made some unspecified efforts to serve the defendants. He's like, well, he's like, oh, I'm not. Well, that's not enough. That's not enough. What did you do? What did you do? Well, from here, Russell doesn't say. It directed the email service should not be the lone means of service, and that additional safeguards are required. And that's true. You have to try other things. Process servers, certified mail, certified with the return receipt requested. You have to do all the fancy things first. And if you guys want to know your own state's rules, look at them. You have to go through all the processes, and then eventually you can just do regular mail. And then if that doesn't work, you might be allowed to use email. So, and this court required a plan to seek and utilize email to demonstrate that traditional service is impractical or impossible due to the alleged avoidance of service. And that's another thing. If somebody ducks service, eventually, if you keep ducking service, they can say, well, I tried serving you. And Greer's made no allegation that Josh was avoiding service and admitted he knew Josh's address in Pensacola. There's nothing here that was done. And it says, regardless, alternative service via email is not authorized by any provision of the federal rules in the federal court system, the Utah court system, or the Florida court system's rules of civil procedure. And the lack of traditional service of process when there are no meaningful contacts is yet another indication that the exercise of jurisdiction would not comport with the traditional notions of fair play and substantial justice. Once again, they're showing like this is not fair. This is not how this should work. These are, and guys, you might say, wow, he's really spending time here. This is, Hardin put in some good work on this because this is very well put together. I'm not saying the other ones weren't, but he put a lot of work in on this. So yeah, and you don't normally have to argue a service of process because most plaintiffs aren't retarded like this. Defective service of process also deprives a court of jurisdiction. Serving a summons or filing a waiver of service establishes jurisdiction over a defendant in only 3 circumstances. One of those is when you're subject to the court's general jurisdiction. Others are when a defendant is not served not more than 100 miles from where the summons was issued, and that is a rule. There's a 100-mile rule. Or where a federal statute expressly authorizes service of a summons. None of these circumstances apply. Utah does not allow for alternative service, except upon the filing of an affidavit. Greer has not established any facts that would lead the courts to general jurisdiction in Utah. And obviously, there's no 100-mile rule. And indeed, at least one Utah judge has already expressly queried whether Utah could exercise jurisdiction over Mr. Moon, specifically in another case Russell Greer brought but also failed to serve. And what they're talking about here is the protection order Russell tried to get against Josh. And the judge is like, I don't know if I can do anything here. But it also didn't help that Russell Greer never served Josh. And say because this court does not lack jurisdiction only because there are no connections to Utah, and because they were not properly served, and even more fundamentally, the process itself was deficient. So what does that mean here? Russell has to establish the burden of the service. So guess what? It's all falling apart. This court should hold that Greer failed to carry his burden and establish personal jurisdiction. There is no proper service. So it should already fail. But Hardin goes on to establish more things. That venue is improperly laid in Utah. And he says, assuming an arguendo, assuming we had jurisdiction, the venue is inappropriate. So venue is only venue, like here's where they talk about venue. How can you establish venue? Well, you can go where the defendant resides because that's always, the defendant can never complain that it's unfair to go where he lives. So for example, if Russell tried to sue me, he could always come to the Northern District of Ohio and I would have no argument to say, Your Honor, this is an improper venue. It's unfair to me because it's where I live. Now, if Russell tried to sue me in like the District for Hawaii, I could say, Your Honor, this is not fair to me. I don't live here. This is goddamn Hawaii. And a court could agree with that. but I can't raise that same argument in the Northern District of Ohio. You're kind of boned in that regard. Now, here's a point. Transfer to Florida would ordinarily be an appropriate remedy, but when last time we did this, Russell Greer filed materially false information, meaning he lied with that court and successfully obtained retransfer back to Utah. And this talks about his friend Steve Taylor, who died. Or the only other place you can do venue is a substantial part of the events or omissions giving rise to the claim occurred. So, for example, if there was a car accident in Kentucky and it involved a resident from California and a resident from New York, okay, well, if the defendant lives in New York, you could serve him in New York and do venue in New York, or you do it in Kentucky where the car accident happened. They say, or if no judicial district would otherwise be available, any district in which any defendant is subject to the court's personal jurisdiction. So if you had multiple defendants where you sue one of them, you could bring the others. And as Matthew points out here, and as I said earlier, in copyright cases, you must do it in the district which the defendant or his agents reside or may be found, which is a problem. We already went to Florida once. So Russell should have done this in Florida. So, as to the relevant venue, the facts are essentially undisputed. Russell Greer acknowledges Josh Moon's a Florida resident. Plaintiff alleges that the infringement happened while Greer was a resident of Utah. But he does not allege the infringement happened in Utah or was connected to Utah in any other way. Utah is thus clearly not the residence of any defendant or the location where the elements of this situation occurred. And lastly, the set forth above, personal jurisdiction over Josh and Lolcow LLC are lacking in Utah. And the Copyright Act requires venue to be laid where a defendant may be found, not merely where a plaintiff resides at the time the plaintiff claims to have suffered the infringement. And it goes without saying that Greer cannot find them in Utah because that was the ostensible basis for an alternative service via email. So they're pointing out that Russell even admits they were never in Utah. So what does all this mean here? Well, they're pointing out because this case previously transferred to the proper venue and Greer improperly sought retransfer, this court should not retransfer the case because he lied and instead dismiss it and punish him for lying. Then we get to failing to state a claim upon which relief became granted. Guys, this is 12B6. So we're kind of back to the old reliable argument here. They say first, Russell must plead the defendants did something other than embedding an alleged copyrighted document from another website, and that the defendant somehow hosted allegedly copyrighted material. Second, Russell must get through the Section 230 immunity. Third, he's got the fair use doctrine problems. And even in the face of the amended complaint, which freely admits Russell Greer's true concern is not copyright violations, but instead geared towards eliminating all internet-based discussion of Greer and his extensive history of criminal activity, stalking, and vexatious litigation. So there you go. Like they're pointing out, there are all kinds of problems for Russell. So he has not adequately pled contributory copyright infringement. Now, this is where Hardin says, notwithstanding the 10th Circuit previously held the complaint adequately pled under a liberal pro se standard, notice they're pointing out this was done because he was a retard. And Russell tried the, "Ya Anna, us a retard" of defense. And the court's like, yes, you are a retard. Good enough for government work. They say Greer has nullified his earlier pleadings by amending his complaint. Therefore, the 10th Circuit's opinion no longer controls, except insofar as precedential value in the same way any other published case does. And Greer's complaint should again be dismissed. And they talk about, to properly plead contributory copyright infringement, you must first prove the existence of a direct infringement. And it says there can be no contributory infringement without a direct infringement. And although contributory copyright infringement is not a cause of action found anywhere in the text of the Copyright Act, courts have recognized several flavors of secondary liability. As to Russell's claims, the 10th Circuit held there are three elements: the direct infringement, the knowledge of the direct infringement, and the contribution to direct infringement. And the 10th Circuit held with respect to his earlier complaint that a reasonable inference from the facts alleged is that the reposting of the takedown notice, combined with the refusal to take down the infringing material, which this is all bullshit, amounted to encouragement of the users to directly copyright infringe. No, it's just because they didn't like the farms. But now that Greer has amended his complaint and nullified his own earlier pleadings, the decision is no longer controlling. And the allegations are nonsensical for purpose of proving that Josh or Lolcow LLC contributed to the infringement. Also, he points out that Russell's allegations doing the direct infringements are most of Chartelli and Rustard. And they appear to have intentionally been filed long after the statute of limitations for those individuals had run, such that Russell will never be able to obtain any judgment for those individuals. It's almost like he intentionally did this. By waiting 4 years in this litigation to name the direct infringers, Russell Greer seeks to allege a direct infringement by those individuals, but to divest his court of any ability to adjudicate a claim by the normal rules of adversarial process. Because if they're outside the statute of limitations, you can't serve them. They're out. They're done. They don't have to be involved. So now Russell could say, well, they're gone. I can go after the people that are left. But this is due to Russell's intentional act. Russell knew about these guys and he let it run out. Now, I don't know if Russell's that crafty, but that's how this is played out. So, and they say because the necessary element is a proof of direct infringement, Greer is asking the court to adjudicate a direct infringement claim, which is several years late. And, you know, it's true. Josh posts all takedown notices he receives, as do numerous other websites. But republication of a takedown notice serves purposes other than contributing, you know, including expressing the reasons the material was or was not taken down, expressing a view that is protected by fair use, or expressing a number of views under the First Amendment. And you're allowed to do that. And also, the posting of a takedown notice happens after the alleged infringement took place and after the plaintiff had demanded the copyrighted material be removed. And this is an issue. So the idea of Josh posting the takedown notice didn't encourage people to do copyright infringement because they had already done copyright infringement. And this becomes the time travel argument. And this is something that Matt Hardin actually called me about and was like, hey, can you proofread this little bit here and make sure it makes sense? And yes, this is the point. The theory of the case is that by posting the takedown notice, they contributed to the infringement. But that argument requires a belief in time travel. Because Russell believes the relevant infringement took place before he sent a takedown notice. Thus, it's difficult to understand how the takedown notice posted after the infringement took place could have contributed to the early infringement which took place before the takedown notice was sent. And allegations that which require belief in time travel are expressly barred under the civil rules because they are implausible. And this is a case from Ashcroft v. Iqbal. I've talked about this before. Twombly and Iqbal. Those are the two major cases involving civil procedure that came out in the first decade of the 2000s. And famously by Justice Souter dissenting. But this is used all the time. And Russell's allegations are a step more convoluted than that. Because he alleges the republication of the takedown notices that do not relate to the copyrights at issue in this case somehow contributed to the infringement of entirely different copyrights. So yes, it's not even relevant anymore. And they talk about embedding the links don't give rise to a liability. Russell alleges the copyright materials were on a Google Drive account. Yes, which is somehow linked to Kiwi Farms. Okay. Russell Greer links the exact same Drive account in his complaint. such that Russell Greer has effectively published his own material to the world on Pacer and courtlistener.com. Yes, you can go and click on the link. And you can click on the link right here, chat. It's there. So good job, Russell. But beyond the absurdity of all of this, Russell's attempt to claim that a republication of a link infringes his copyrights, even though he has repeatedly shared the same link in public documents, there is yet another problem. The so-called embedding of a website does not give rise to copyright liability. And that's something that's happened before, and this court has explained how embedding links works. It says, in short, one website might appear to display content without actually hosting the content. And it says, if a party displayed a copyrighted image that it stored on its own systems, then it infringed. If it displayed an image by linking or framing the content to other websites, then it hasn't infringed. So this is binding authority out of this court. There you go. So Russell even alleges that there's a link hosted to a Google Drive, but that is per se not an infringement. And the link content is hosted by Google, in which Russell needs to sue Google, and he won't because Google will kill him. Very much like Acer Thorn. Acer Thorn tries to leave out Google because Google fucks his cases up every time. Google brings in their attorneys who effectively crush him. And by crushing Acer Thorn, he also helps out the other parties he picks on. So there's also Section 230 claims that are barring things here. And Section 230 of the Communications Decency Act says, no provider or user of an interactive computer service shall be treated as a publisher or speaker of any information provided by another content provider. Okay, so there you go. You protect websites from liability for material posted on the website by someone else. It's a robust protection. To show you're entitled to protections, a defendant must establish that they is a provider or user of an interactive computer service, and the farms are. The plaintiff claims hold it responsible as the publisher. Yes. And 3, the relevant information was provided by another information content provider. Yes. Some farmer put it up. So there you go. It's not the problem. Greer admits the farms are an internet forum. And this court previously held the farms qualifies as an interactive computer service. So there you go. And this court has also held Greer seeks to treat the farms as the publisher or speaker of third-party information. So the only element of Section 230 this court has held was not established is whether the relevant content was created by third parties. So there we go. Now, as Russell clarifies, he does not seek to hold Mr. Moon responsible for the statements he made. Instead, he seeks to hold Mr. Moon liable because he knew about the activities of various third parties. Basically, only on Josh's knowledge. You can't do that because mere knowledge of an infringement does not establish contribution to the infringement. And Russell Greer has not explained under what theories he's seeking to impose liability on both Null and Lolcow LLC. But here's the issue. He seeks to hold the farms and Null responsible for the actions of Mosif Jartelli and Rustard. He also seeks to treat Josh as personally responsible for the actions of Lolcow LLC. And even more frightening, the complaint consistently seeks to allege that Josh is personally responsible for the actions of unspecified users. And that's not how it works under Section 230. So therefore, it should fail. Then we got into fair use. Remember, guys, fair use is under the Copyright Act, and you can use fair use. So when you're trying to do this, there are 4 factors for fair use. The purpose and character of the use, including whether it is of a commercial nature or is nonprofit educationally purposed. The nature of the copyrighted work. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And finally, the effect of the use upon the potential market for the value of the work. And although it's an affirmative defense resolved on summary judgment at trial, You can use it as a basis for a dismissal when the facts necessary to establish it are evident on the face of the complaint. And the complaint squarely establishes that any sharing of Greer's book or song would have been fair use. Greer does not allege that anyone else profited from his stuff, nor does Greer allege there was a commercial nature to any infringement. Instead, Russell alleges consistently that the individual shared his materials in order to mock or degrade him. Satire and critique are fair use. Similarly, Russell Greer alleges that only 2 posts on an entire internet forum, which contains over 100,000 posts relating to Greer, constitute contributory infringement. And through the declaration of Josh, and he says the amount and substantiality of the commentary outweighs the amount and substantiality of Greer's books by several orders of magnitude. And then finally, Russell doesn't allege that the market value of his copyrights have been impacted, but instead it's criticism that upsets him. The only reason these were obtained is to criticize him. Russell complains the true harm to the market comes from criticism and negative reviews, not because individuals are competing and selling it or taking his opportunity away. And because of that, the court should dismiss the totality of the circumstances in this and dismiss the entire complaint for lack of jurisdiction, improper venue, and failure to state a claim. And alternatively, the court should screen the amended complaint and pierce the veil of factual allegations and then dismiss it because Greer cannot corroborate any of his allegations. Because such allegations are manifestly frivolous. And that's where we go here. So there's... Oh, hold on one second. I just got a note from my producer here. Hold on. What is this? Let me see. Oh my God, that is brutal. Oh, chat. Oh no. Oh no. Oh no. Oh my God, chat. We've got a, as Alyssa told us, it's almost 11 and there's still no stream tonight. Touching on the Nick Ricada question. But this popped up on the forums just a little while ago. Minnesota Public Records saying, what is the exact time of the stream? Uh-oh. Uh-oh. Oh, no. Oh, no. Kitty's right. Yo! Oh. Yes, an interesting matter of public record is attached. No, the PSI will not be released. That's a confidential document. So, whoa. Ooh. And a hush fell across the room. So there you go. Someone get this to the casino bros. Well, there you guys go. That's the post number. 167-55544. Oh, buddy. Ooh. I don't know. I don't know there. So anyways, let's get back to this. So they want to convert the instant motion to dismiss. Yeah, I don't know what it is, guys. So anyways, signed by Matthew Hardin. This is a kill shot. And I know some people out there are saying, and I saw in the comments, and I didn't want to address it too much because I feel it kind of takes away from presenting later. The fact that these arguments were already raised by Scortis or waived by Scortis, it's a new complaint. So everything is timely again. And more importantly, make the arguments and make the court deny your arguments in this situation. I think Hardin did the right thing here. I think this worked. So this is an impressive way of handling it. This was very well put together. This is very well put together. This might be a kill shot. It's nothing ever happens a clock, but oh my god. You know, I was gonna do Matthew Hardin up on the balcony of up on balcony of the house over the camp, and Russell's gonna be sitting there tying his shoe, and you know, he was gonna take a cigarette and put it down, and you know, stretch out with the rifle and just go bow to Russell. But I didn't do that one. I didn't do that one. So the judge isn't reading this until oral arguments next month. Yes. But it's important to get this in now so the court can respond, because Russell's going to get a chance to drool and respond. But that way there's enough there. Because the oral arguments for this, guys, like, I don't think you understand. The oral arguments for this are going to be lit. And I'm hoping we can hear these, because I'm going to try to make sure I'm available and I have time to listen to these oral arguments, because I think they're going to be amazing. And I want to be able to hear them so I can give you an idea. Yes, no Schindler's List. I had to settle for Splinter Cell. I hope you guys appreciated that. Matthew Hardin playing the role of Sam Fisher. Yes, Matthew Hardin's all prepped up in the book depository. Oh, I mean, chat, this is oof. Now from here, the proprietor of the Kiwi Farms, a website, Joshua Moon, did do a declaration. So you can read this in Null's voice. I'm going to read aloud. And he states as follows: "My name is Joshua Moon. I am an adult resident and domiciliary of the state of Florida. I am the sole member of Lolcow LLC." And he says, "I am competent." I don't know about that, but he says he's competent. And then he can testify to matters set forth here, and based upon my own personal knowledge and based upon my knowledge as a sole member custodian records of Lolcow LLC. He says, "I've never been to the state of Utah. I've never intentionally conducted any business in the state of Utah. To my knowledge, I have no systematic or persistent contacts with the state of Utah, except for those which have arisen as a result of this litigation, in which I have been forced to retain Utah counsel and appear in a Utah court. Lolcow LLC does not do business in Utah. To my knowledge, there are no contacts except for the result of this litigation." And he says, "I'm aware of this court's order granting alternative service upon the defendants. In that order, the defendants appear to have consented to receive service by email. The court cited a document filed at 15-1 for that proposition. 15-1 is a copy of the website as that site appeared in February 2021. Although I am the sole member of Lolcow LLC, I do not maintain in my personal capacity the website which is printed out on 15-1. The website explicitly refers to service of DMCA complaints, not civil complaints. Under the DMCA, copyright agents are required to provide their email address under 17 USC 512. Takedown notices are routinely sent via email under that statute. Neither I nor Lolcow have received service of a complaint via email." And I think it's really fucked up. Scortis fucked all this over. And he says, "I reviewed the records of Lolcow LLC. The contact us page as of 2020 contained the following information. For servicing, this is how you service." And he says, "I've never," and this is where he's serving, like, for service of process. "I've never consented to service a process in any civil litigation via email. Nor have I consent." And here's the thing, Russell should have that email somewhere. "Nor have I consented to service a process against me personally, merely because such service of process is received at my LLC. Lolcow LLC never consented to process in any civil litigation via email. Lolcow LLC may be served through the West Virginia Secretary of State. It was formerly capable of being sued through a registered agent, but because of the whole Keffel shit, that agent had to quit. To the extent that Lolcow LLC was susceptible to service via certified mail, such mail should have been addressed to the address in paragraph 6 above. There was never any time where service by email was acceptable. The email address for legal at Kiwi Farms is owned by LolCow. My personal email address is jcmoon@pm.me. And, this is the part here. It says, Russell Greer never provided me with precise URL he alleges contains copyrighted material. Instead, he generally linked to kiwifarms.net or his thread. Kiwifarms.net is a website that contained hundreds of thousands of individual threads. Indeed, Greer on April 19th even told me, I don't need to identify specific URLs. Greer is a topic of discussion in at least 2 threads right now, although occasional mentions of Greer happen across the entire site. One of those threads currently has over 16,000 individual posts by users spanning 811 pages. The other thread has 91,000 posts spanning 4,582 pages. And yes, the farms are an internet forum which allow individual users to discuss events and individuals. Those who use the website discuss Greer among other individuals and comment upon his history of civil and criminal litigation, as well as his behavior towards women, which to date has resulted in the issuance of at least 3 protective orders, which is true. They discuss also his history of vexatious litigation. And they make Greer worthy of criticism. They also discuss Greer's musical compositions, which many users feel are of an inferior quality and lack artistic merit. Just null is just fucking sinking in there. He says, I'm given to understand that Greer believes there's a link to a Google Drive. I don't control Google, and I don't have the ability to take down any material hosted on a Google Drive. I did not personally post any material on any Google Drive, and neither did LolCow LLC. I have no ability to remove the offending material. I'm given to understand that Russell believes there is an MP3 file containing a song which he alleges is copyrighted. I did not post it. Neither did LolCow LLC. And any individual posting it likely did so in order to comment and criticize his book and music. And he says there are over 5,000 pages of Russell Greer discussions on Kiwi Farms, according to Amazon. His book is 175 pages in length. Thus, even if Greer's book were posted to Google Drive and discussed by any user, it is evident the commentary far exceeds the content of the book. Similarly, because there are over 100,000 posts, many users express a negative view towards Greer's musical talents. It is evident on the whole that any incidental reproduction of one song in one post out of 100,000 would be a fair use for purposes of commentary and criticism. And Josh Moon declares under the penalty and perjury, the foregoing is true and correct. Joshua, I think that's what he says. So, Joshua Moon, if that's your real name, sir. Has a judge ruled in this filing yet? No, it's just come out, guys. It came out this week. This is like brand fucking new. This is brand new. So nothing's going to happen yet. Nothing's happening yet. So, yeah, Gershman. Yes. Gershman. That's how we read it, chat. Jody over on Rumble says tickle the plussy. Well, thank you. And BCM 10 says first, Sean, the Rumble seed. Yeah, there you go. Sowing those wild oats over on Rumble. Over 5,000 pages, the farmers need a new hobby. Well, Ellie, remember, Russell's been around forever. Russell's been around for years and years and years. And hold on, I mean, like, if you guys, like, Russell Greer he's not, like, this is not his first time around. And hold on, I gotta switch over to my potentially criminal one because you guys don't need this one. I gotta save my actual hidden one. So we have, let me see here. I'll bring this up. Let's see. Hold on, chat. Also, there's a lawsuit Russell filed in his ability to run whores out of run whores out of Nevada, and then we're going to take a look at the Gilman case. That's some stuff out there. Useful Mistake has gotten a hold of. I'm going to take a look at that stuff coming up here. Let me see here. Where is... So, for example, guys, Russell Greer's stuff, it goes back a long time. I'm trying to see if I could find his original page. Let me see here. Yeah, here we go. Here's Russell Greer's, Russell Greer has right now, and also C-Chat, potentially criminal. You're not going to find my real name on here. But like he's at 4,584. Let's go to page 1. How far back does Russell go? 2017. So this isn't like Nick where it's all exploded recently. This goes back almost 10 years. Right now it's a 9-year-old page. Oh, sorry, chat. Sorry. Russell Greer goes all the way back to May of 2017. May Day. And this is Russell Greer. Some dude named Russell29. That's his Instagram handle. A Safer Nevada PA Political Action Committee. This is his political action committee for increasing brothels. He likes hookers. So this is a long time. This is a long, long time. So there you go. It's a little different there. How am I older than Sean? He's more of a boomer than me. I don't know. It's one of those things nobody will ever know. Does Russell still work at Walmart? No, he works in he's some file clerk or something like that right now. He's got an office job. Hookers are made for fight. Hookers are made for murdering. That's what hookers are made for. Yes, Amended public records are back. Let's go. Although, chat, remember, as we just do need to address here, because it is almost 11. We need to address this here. Because it is almost 11.
Almost 11, and it's still no stream. It's almost 11, and it's still no stream. And Baldo ain't streaming tonight.
I know, but it's almost 11 Eastern time, so that we got to start here. We got to do it twice. Anyway, there we go. It won't be until midnight Eastern. Who really knows? I don't think it'll be even then. I'll do it again later. But that is where we are, guys. That is the totality of everything we're looking at. So we need to catch up on some things here. John Simmons been a member for 3 months. Thank you for being here. Thank you for the support. It's not jaundice. Thank you. And then Robert Lawrence gifted 5 subs. Fred Rush gifted 5 subs. Amateur Iconoclast gifted 5 subs. And EDW Raptor gifted 10 subs. It's a lot of memberships, chat. We are making America green again. We are praying the gray away. We are getting those H1 green visas. Grays, you got nowhere to run. You got nowhere to hide. They're coming right after you. They're coming right after you. I mean, these guys just see grays walking down the street, and they've only got one thought in their mind. That's all when they see you. That's what they're thinking. Vince Griswold for $5 says, when Nick starts overtly abusing prescription pills in place of alcohol, will that break his parole? Yeah, it can. Royston as Bailey for $2 says, Nick enjoys probing, but he won't enjoy probation. That's very true. Chugi Show says, late, and remember, it called And remember it called potentially criminal. Not criminal. Don't talk to the cops or joke about committing crimes. Yes, thank you. Been there, done that. It's been a member for 12 months. Thank you for that support. Says, I bet Russell Greer lives on Skinwalker Ranch. I guarantee you if Russell Greer starts walking around Skinwalker Ranch at night and runs into the monsters, he goes, Mommy, Mama, can I have your Skinwalker hookers? I'm sure those guys are going to be like, ah! He'll scare them all off. You know, he's going to ruin the secrets of Skinwalker Ranch by fucking drooling everywhere. I'm sure that's what happened. Like, they come out for the show one day and there's like goop in the bushes and they're like, what did this? And Russell's like, me. Epic Fantasy. I know you took off a little earlier because it was getting rough. And I know it wasn't your speed there. I'm sorry about that. Says, Ricade is an entitled, malignant narcissist, and even the slackers in Minnesota couldn't look the other way. Yep. Mark Tryon says, Nick took ownership of all the drugs to get his wife and side piece cleared. This does mean you will take all the heat. This does mean you take all the heat. I mean, me? I guess. Justice Smith says, almost like what Sean said would happen, but worse, because I don't even think Sean would have guessed 5 years of probation. Lamau. Yeah, I didn't think we were going to get 5 years of probation. I think that's a fucking lot. I think 2 years, like that's what it would be here for this type of thing, 2 years. But if Nick in his PSI acted like an asshole, and if the investigation into him revealed him doing all this, drugs are cool. I don't understand the big deal. I'm sure that they're like, we need to buck break this guy. Very likely. Wrestler Town gifted 5 subs. Thank you very much. You're doing your part out there, chat.
Fight for the future.
I'm doing my part.
I'm doing my part.
I'm doing my part.
I'm doing my part too.
They're doing their part. Are you?
Are you? Are you doing your part? Something to think about. Think about it. Think about it. Am I going to eat a bunch of eggs this weekend? I mean, maybe. Maybe I'm going to boil some eggs up. Maybe I'll boil up. And we got our. I had to go pick up the stuff at the store, and yeah, we might go do that. I might boil some. I don't know if I'll do deviled eggs this weekend though. I don't. 2.0 is a big fan deviled eggs, so just some hard-boiled eggs, never a bad time. JC says that me being Fap Cop would be too much to handle. I don't like Fap Cop likes Russia. I don't like Russia. So no, I'm not Fap Cop, I promise. Prey times 12. How was court today? I went pretty good. Somebody got sentenced today. They got to walk out the front door, which is always a great day. We had a video hearing, went really well. And then I had a hearing in the afternoon as we were trying to get ready and get through part of it. One of the participants in it ended up getting arrested. So kind of fucked everything up. So that kind of turned into a dumpster fire. That was when I had to leave layback law. It was at 1 o'clock. That was kind of like a... So we're going to try again on Monday. We're going to try again on Monday. But thank you for asking. But yeah, nothing like being at court at 8:15 in the morning. You're just like, fuck. Whose idea was this? And I'm like, wait, this is my idea. Epic Fantasy says, Fap Cop being Sean, we better than PPP being Sean using a VTuber persona. Oh, hold on 1 second. Yes, what's up, baby? Oh, Runkle's here? Where did I miss him? Oh, hey, Runkle. You're out of the loop on this one. Are you talking about the thing with Nick or this case? Because I can run through the case real quick if you're not sure. So I'll look to wait and see your thing here. There's Runkle at my house talking about the farms things. Also, Nick. Okay. So Nick got 5 years of probation. He's on, they're doing the deferred adjudication stuff for him. He's got through basically the summer to show that he can abide by terms and rules of probation. And if he does, then he doesn't go to jail. If he fucks around, he's got 30 days of jail hanging over his head. So basically, this is going to be the summer of his discontent. He's not going to be allowed to have fun. He's going to have to go do drug and alcohol assessment, no drugs, no alcohol. He's going to have to go to cognitive therapy, which is basically they sit you down and say, quit thinking like an asshole, think like a law-abiding citizen. That's really kind of it for Nick. I can talk to you more about that later. As far as this case, so Russell Greer is a sex pest. He tries to, he tried to sue Taylor Swift and Ariana Grande basically into going on dates with him, and then he'd hope they'd play with his wiener. He's a creep. At some point, he wrote a book where he talks about, like how I became known as crazy and vexatious. He makes these shitty songs that he contracts out on Fiverr and all of that. Well, the Farms then found all this stuff, and it's on a Google Drive Google Drive somewhere, and someone linked it to the Farms. And because Russell can't afford to sue Google, because Google will crush him, he sued the Farms and left out all the other parties. And he's claiming contributory copyright infringement, meaning the idea is that the Farms and Null allowed and encouraged the infringement to happen. This case has been dragging on for 4 years now. It's been going on forever, and a lot of the reason is because the courts give him the benefit of the doubt because he's pro se, and they let him pull the "Your Honor, I'm just a big retard" every time. But the case is disintegrated because Russell's never gotten this far in any of his other lawsuits, and Russell's very litigious. He is a vexatious litigant. He sued a lot of people for a lot of things. He's never gotten this far in a case. He survived the motion to dismiss, and he only survived because the Court of Appeals overturned the district court. So Russell is stuck. He can't do discovery. He's failing at discovery, and he's basically admitted, I have no witnesses and no evidence I intend to present. In the meantime, he has been sanctioned for discovery, misconduct, and other things, and this case is starting to wrap up. It's just taken forever. Yes, and this right now he's not going to get labeled vexatious, but this is going to be the death knell of this case. So I think that kind of answers everything you need there. So I hope that makes sense. If you need more, I can explain it to you, but that's like the 10,000 foot view I can give you. But yes, this would be better than me being PPP, being me using a veto persona. Jeez. That would be a lot of levels of insanity. Anyways, guys, Runkle the Bailey's out here. Hold on, let me see if I can. Just saw his link. Guys, Runkle the Bailey. Ian Runkle does great stuff up in Canada. Does great things, great coverage of a lot of different stuff. If you guys haven't watched him before, definitely take a look. Very entertaining, very good guy. Very pleasant to talk to. You might be getting sued by a guy who sent me a letter with the red ink thumbprint. Ooh, that's fun. That's fun. Oh my God, I'd love to go over that letter. That would be hilarioso. But that's what you get for challenging some sort of free man who's on the land. All he's trying to do is live his life. And you're interfering like that. Shame on you, sir. Shame on you. You had a fun reply to him. Thank you. Now, are you sure the thumbprint wasn't blood? Because that would be the creepy part. But yes, chat, that is a level of sovereign citizenry using thumbprints. That's a real thing. They think that's critical. My reply back to him basically was, I want to treat your letter seriously. It deserves. Here's a picture of a monkey. It's not blood. It's bright red, not brown. Okay. So. Jim says, did I see Trump tweet about those knuckle tattoos? I sent it to you. I didn't see that yet, Jim, but I still don't think those are... That guy doesn't have MS-13 tattoos, so I don't think they are. I don't think they are, but I'll take a look. I mean, you think they would have seen them already, so. All right, so what else do we have here? Let's see what's some of the other comments. Rob the Trucker for $5 says, Sean! Thank you, Rob. Blah, blah. Just not blah, blah, blah. Says, hey, sorry if this doesn't make sense. Can you tell me the album about a guy who didn't have a shadow or something after the atomic bombings? Yes. That is the band called Wishful Thinking, and it's a song called Hiroshima. I don't know the album name, but yes, there's a shadow of a man at Hiroshima when he passed the moon. And it's funny because it's an anti-war song, but it's pretty dope. It's by the band Wishful Thinking. It's on a album called Hiroshima. Because it's the idea is that on one of the buildings at Hiroshima on the steps, there is the shadow of a guy who got burned into the concrete and the stone when the atomic bomb went off because he was sitting there as he got vaporized. So, yeah. Did the album bomb? I don't know. Funny. But it's a very, very good song. I really like it. It's got it starts out pretty good. Then it's got this nice part in the middle where they just start riffing. It's actually pretty good. It's not like, it doesn't sound super like anti-war either. It's just they're singing about it. It's like, it's pretty good. It's pretty good. I like it. I'd play it, but we'd probably get taken down for that. Shadow on the Wall by Mike Oldfield is good too. Yeah, it is. Still not as good as, Standing on the Edge of the Crater, like the prophets once said. I can't do it like the guy used to do in front of the Shia LaBeouf thing, but it was still pretty good. Let me see here. Send Runkle the link. I don't know. I think Runkle's been busy. He's been busy doing a lot of things, and he's probably sitting there with his dogs on top of him. So I don't want to disturb his doggos. I bought the Hanson CD in middle school. He told me no, but I will say if you really do want to hear Hanson in their now, it actually all their stuff sounds actually pretty decent. Not gonna lie. Listen to those guys singing Bop now. That actually sounds really good. A lot of their stuff actually sounds pretty decent now. Keith Carter says they copyright nuke their stream. Yes, they would. You're playing video games, drinking a beer. Well, there you go. PWR sings better. Well, I can't beat him. That man has a head fit for a crown. That man has shoulders that can carry us all. I don't put myself in the same league as PWR, and I hope PWR sees this. I defer to him. I'm not going to call him the King of Kings, but he is definitely a king. So, but anyways, I hope that's what you're getting at. Blah blah. It's called Hiroshima by Wishful Thinking. Burr Range says the PSI will be released. No, it's confidential. PSIs are confidential. There's confidential information. The sentencing recommendations are confidential. Other things may be confidential. So no, you guys should never be able to get a copy of it. Unhung Hero gifted 10 subs. There we go. Very nice. Very nice. Thank you for the support, Unhung. I appreciate it. Minnesota Knows saying for $9.99. In an unrelated matter, it seems the University of Alabama at Birmingham Hospital illegally harvested organs from inmates held by the Alabama Department of Corrections. What the? Hold on here. What? UAB organ harvesting. Really? Ooh. Oh, this looks okay, hold on. Alabama. Wow. Okay. It's from a little while ago. The state of Alabama gave the hospital permission to harvest organs from dead inmates. What? Ooh. Wow. So yeah, your family member dies in prison and all their organs are gone. Oh. Oh. Oh no. That's not good. That's not good, chat. Oh, buddy. They claim that happened. Like this, the school's like, yeah, we were told we could do it. Woo. Yeah, were there Chinese students running this program? Good golly. Armbrister says, why does Lauren Boebert keep screeching into the wind? What will happen when the admin just tells them the DOJ won't enforce your rulings, period? You mean Boasberg, right? Not Boebert, because you mean Lauren Boebert. You mean Judge Boasberg. They're not going to. That the Trump administration is never going to do that. They do that, the game's over. Jig's up. If they do that, it's completely at the end. So they can't afford to do that. They don't have that kind of political capital. And I wouldn't like it if they did that too. If they just flat out said fuck off, I would not like that at this point. They've been able to make do and work around things, so do that. But if they did that, I'd be done too with it. So they get to the point where even I'm out. So yeah. So hold on here. What is this? All right. The Minority Reporter says, Nick Kato told me I could harvest those organs, bitch. Oh. Ronco says, were they eating them? I don't know. GTO says you can't harvest from the dead. I understand, but yes, they were brain dead. They were probably declared fake brain dead to get them. Yeah, who knows? We don't really know. The problem is the families never got to do that. Yeah, Boasberg. Okay. So, Access, and you guys wonder why I freaking do research on plants. Well, it's because you want to bring back chattel slavery. Amended Public Records is the judge. Boasberg just got smacked by the DC Circuit 3-panel. I'll have to take a look for that. Half Irish says the practice is secting, maybe, but it doesn't matter. You have to have permission before you do that stuff. You can't just take shit out of bodies. You need permission for that, and you need permission from their families. And if you're not getting it, that's illegal. So, let's see here. So, thank you for that, Minnesota Nose. I appreciate it. Fair Frozen 55. Good to see you, man. It's been a little while. Hope you're doing well. Russell is old enough that when Nick started streaming originally, he had several sagas, his Bunny Ranch visit, his failed orphanage. Yes, he tried to make a home. He was going to do the Professor Xavier's, home for gifted and talented horrors. And that other pop star he tried to, date. Yes. That's funny because Nick used to cover this stuff back in the day. How times change. Keopathic says, for $2, Sean said no jail. So much for a practicing lawyer. Well, actually, he didn't go to jail. He still didn't go to jail. Robot Glock for $10. That'd actually be a good Glock. Just one that automatically just starts. One with a switchy. Just go. Speaking of switchies, you gotta love your switchies.
No talk. No cap. No talk.
No cap indeed, chat. No cap indeed. First thing in the AM, but late AM, but before lunch, right after lunch. Last hour of the court day. Which one should I or someone schedule sentencing to maybe get a feel-good judge / a light sentence? I mean, it all depends. I mean, some days judges might have a shitty day and you might end up taking the brunt of it. You might go right after some guy who completely fucks things up for you. That does happen. Most judges are pretty even-keeled, though, that they don't import that on you. But yeah, I mean, like, if you're the first one in the day or early in the morning, that's never a bad idea. I do think there's some tactic to that. You know, if it's getting towards a nice weekend, the judge has kind of like been chill, taking it towards the end of the week, getting a Friday afternoon or a Thursday afternoon. Like, sometimes there's benefit, but reality, it's all about how big of, were you an asshole? Have you been an asshole on bond? And how is your judge just an asshole in general? Those are the things that matter. Those are really what critically matters. But thank you for the super chat. And then Minnesota knows for 1999. Thank you. Thank you very much. Let's see. Let me see here. I don't know if it's real, but the Children's Hospital at UAB did my daughter's open heart surgery. I will give them the benefit of the doubt unless and until evidence proves otherwise. Well, I mean, like, they admitted to it. We just saw the article. Like, they're like, we 100% did it. We were given permission by the government to do it. Massachusetts had a dude stealing body parts from Harvard. Shit is wild. Oh, yeah, it is. The stuff that happens in medical stuff is so fucked up. Yeah. You guys are saying I'm claiming I'm not wrong. I'm telling you I was right. I'm not claiming nothing. I'm not claiming nothing. I have made an edict. I have spoken it into existence. It is my dictate. It's not a suggestion. It's not a thought. It's not a pontification. I have stated fact. I've stated fact. Oh. So, yeah, there you go. Mickey says, Sean, if Nick moved to Miami down by his millionaire dad, for example, would his sentence be transferred to Florida, or is it only enforceable in the state of Minnesota? So the way probation transferring works, you're allowed to transfer to that other place, but your original court holds the jurisdiction over you. Other places are merely agreeing to supervise you. So, for example, if you violate probation and if you're in Ohio and you move to Pennsylvania, the court in Ohio still holds the case. It's just Pennsylvania's agreeing to do it for you. And they notify Ohio, hey, Judge Sean, hey, we're over here in Pittsburgh and this defendant Bob, is not doing things right. He's testing hot. As a judge, I'd say, all right, well, we're going to have a probation violation hearing. Bring him back. And if Bob runs, we put a warrant out for him, we drag him back. So, no, moving away doesn't alleviate things or make it any better. And then Runkle is saying, I could see Nick mouthing off to a probation officer. Oh, I 100% could too. He calls him the fun police. You're not my dad. I'm sure he will have a rough time with this. I'm sure he'll have a rough time with it. Sadly. Shinobu Tezuka says, unless he moves to another country, he would need permission to leave. So he needs permission to leave. And the other thing is, if he moves to another country, let's say he just runs and hops on a plane. Okay, so they put out a warrant for him. If he ever came back to America, that warrant would trip. So he'd never be able to come home again. And I don't think Nick can do that, would ever want to do that. So, yeah. So, how many Haitians have I had to represent in court? None. The little Jen that could said, is this Bob Boberson guy committing crimes in Ohio and Canada? Yes. He's like Carmen Sandiego. He's an international criminal mastermind. Yes, he'll tell the probation officer, stop touching my Transformers. Oh. It's all your fault. You should have painted Warhammer minis with them. Well, I'm doing the bolt action minis, which those are coming along pretty cool. Let's see here. Zakona says, if Nick gets another speeding ticket before August, will that factor into jail, or are those viewed differently? Well, it all depends what he does. Generally, if like he got a speeding ticket for going like 30 and a 30 or 30 and a 25, no. If he got a speeding ticket for going like 90 in a 35, yeah, that would be a problem. Like if he's getting really out of control. Sure. But just a minor thing like that, or let's say he was driving down the street and the cop noticed, hey, your turn signal's out, and he got a fix-it ticket. No, that stuff wouldn't matter, really. Now, if he gets like 1 million speeding tickets, yeah, that could be a problem. So, the Ricada and Ralph show would clean up. I think it would be good initially, at least. Would he be flagged in airport databases while he's on probation? Well, he's not on parole. Parole is when you're released from prison. Would he be flagged when he's out there? Well, he's only flagged if you're going through leads. But even then, there's not necessarily a lot of information. Like in the state of Minnesota, yes. But that's not guaranteed when he goes anywhere else. Because if he's allowed to go anywhere, like if he presents travel documents, there's nothing stopping him. So he'd be allowed to travel around. He got permission from, his PO to go on, like if he wants to go to Hackamania or whatever. Yeah, then he just goes. Oh, if he got a DUI, yeah, that would be toast for him. Alpha Fox says Carmen Sandiego was sexy. You never got. How do you know? How do you know what's under that trench coat, brother? Oof. That trench coat might have a big old dong hiding underneath it. Be careful. You never seen her face, too. Oh, you guys, it's cute. You guys are fighting in chat. Let's see. Where did I catch up? How far behind am I? Yes, Carmen Santiago. No. Yeah. Carmen Sandiego. Sean's always talking about dongs. Well, I can't let you feel alone out there. I'm there to help you. I'm an ally. It's 2025, bro. It's okay. He already said Carmen was sexy and he doesn't need more enticing. I didn't know that. Bella says, I'm missing fights. No. Carmen the whale's penis. Jesus. I get that joke. James says, I'm hungry. What sandwich would you recommend? Make a grilled cheese. Nothing wrong with a good grilled cheese. Yes, I talk about dongs and Hella talks about taints. And I saw Hella in chat. Hella, I hope you're doing well. Yes, as Jordan Peterson says, wash your penis. Do a grilled brie? No. Could Trump deport Ricada to El Salvador as a terrorist? No. Grilled cheese is good for Lent, yes, but we're past Good Friday, so you can, do whatever you gotta do right now. Did I see the New Mexico judge that got caught with TDA members living in his house? No. Send me a link to that. That sounds interesting. Moose Nut says, total win for the toe. President Trump to present Aaron Imholt with the Lifetime Win Award. Yes. The Presidential Medal of Freedom. My uncle said that to tattoo Nick's knuckles first. Yeah. That'd be so funny. Get his little Japanese. They'd be like, "Oh crap, he's got Japanese characters on here. What do we do?" Malka says, "Now that Lent's over, I could be racist again." Oh my god. I'm dragging out the stream in hopes of Nick streaming so I can raid him. No, we're not going to do that. Imagine a presidential medal of Sonichu. You know, Matt, like if I got invited to the White House and Trump's like, Sean, we're gonna award this to you. You got the best medals, everything, the best medal courage. And he pulls a Sonichu medallion out, I will punch him in the fucking face. Like they'll be like, I'll grab the American flag thing that's there, or you know, like he's got the army flag with all the streamers on it, the battle streamers. I'll grab the fucking army flag with all the streamers on it. It's got the point on the end. I'll be like, get back, get the fuck back from me, sir. And I'll be like, I'm leaving. Let me go, and I'll back up. I'll back my way out of the White House. Like, I ain't fucking doing that. I ain't taking that. That's sedition. Offering the Medal of Sonichu is sedition. I'd be going straight over to the Capitol building demanding he get impeached. So, thank you, Jim. I saw that. I'll take a look here. Oh, why is this? What the hell just happened? You click on stuff and like the window changes. It's a little ridiculous. So there we go. What do we got? What do you do? What do you say? Oh, wow, Jim, I'm going to have to take a look at this here because this is interesting. Wow. Dude, jeez. I'm going to have to... I need to see links to stuff, and this guy doesn't have links to this thing, so I'm going to look for some of this. I'll do some looking. That might be good fodder for next week to cover. So, guys, that is it for us. I think this is the end for Russell. I think it's the end for Russell. I think this is going to be it. With that said, we are going to do a model stream tonight. We are going to go back to working on the MiG-37B. And some of you might say, wait, what's the MiG-37? So this is a kit from 1987. This is back during the Cold War. So we didn't know what experimental aircraft were looking like. And at this point, by 1987, it was, what do stealth airplanes look like? So this is the model company, Testers in Italieri. They worked together on developing what they thought a Soviet stealth fighter would look like. And ironically, it looks more like the F-117 Nighthawk than what they interpreted the American option to be, which was the F-19, which is like this weird curved thing that kind of looked like the SR-71. They were actually more correct with the Russian version. And we've got this old 30-year-old model kit. We're going to work on putting it together. We can put some of it together and we can paint it tonight. So we're going to do that coming up here. And I need to set up the stream. So you guys give me 1 second here. Hold on. All right, hold on here. There we go. Okay, flatten image. So much work to make thumbnails. A little frustrating at times, but it's a lot of fun here. So, yeah, we're going to go over to the model bench because we're almost there to getting that thing up to 500 subs. We're almost there. We're almost there, chat. Like, it's getting close. It's getting close. And just remember, chat, it's almost 11, and there's still no stream tonight. So I think I've caught everybody up here. Like I said, I'm just trying to... Give me 1 second. I'm trying to set this up. All right, what time is it right now? It's 11:27. So we'll start this for 11:35. Just give it a minute or two. So we'll get started here in like 2 minutes. But I'm going to send you guys over there now, so it's time to go. Tonight's the 250th anniversary of Paul Revere's ride. Thank you for pointing that out. 1 if by land and 2 if by sea. Yes, one of the true American heroes out there, a true patriot, Paul Revere. Getting it done out there, chat. So here we go. Hold on. All right. We're going to go there, chat. So I will see you guys in a little bit. If you could, just please go over there and kick over a sub. I would appreciate it for the channel. I should build a NIG 44 codenamed the O-Bomber. Thanks. I'll work on that. Aussie Mark says, so Nick can still be a cuckold, but not a drunk. Yeah, that's correct. Both things are correct, Aussie. But you're already eeping. No, I'm not. We're ready to go. So, chat, thank you again for you guys being here. I appreciate all your support. Remember, chat, guys, if you're watching it, if you're liking it, if you're subscribing, if you're commenting, anything you're doing, I appreciate all that support. I really do. It's very humbling. And every time I do this, you guys are always humbling, and I appreciate it. So, thank you again. And remember, till next time, chat, just because you did it does not mean you're guilty. Not mean you're guilty. Unless you plea out. Well, then you are guilty. So, good night, chat, and take care. See you guys in a couple minutes.
Weapons, blacksmithing, and models of planes, esoteric works, and
you don't have to worry about going anywhere. It will redirect you. So you're all good. Don't worry.
even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops.
Also, happy Easter, everybody. Remember, he is risen and Christ is king. So happy Easter, everybody. He did it for you. He did it for you.
Even when they nab you on illegal stops, just cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick hated yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go. Here on Sean Martin's Potentially Criminal Show.
EDW after $5. Redirect D's nuts. Thank you. Thank you so much. Also, real quick, you guys need the link for where we're going just in case it doesn't get through. Hold on. I'll give you the actual link here. All right. Hold on here. I'll put that in the link below. That's in chat now. See you guys later. I'll see you over there in like 2 minutes.